Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics relevant to people living here in Utah. Today we're continuing the series about what a minor child can inherit, to get you thinking about how you are going to leave an estate to a minor child, whether a child of your own or a grandchild, and what that arrangement is going to look like. Specifically today we're talking about bank accounts. Can you leave a bank account to a child? Yes, you can. There are multiple ways to do it. One of the simplest is just to leave it to them. However, their guardian and conservator is the person that's going to be managing those funds. And if that's an unknown, which it always is, you never know who the guardian and conservator of a child is going to be. You don't, even if it's their parents, you don't know what's going to happen to the parents before the child turns 18. So it's best to avoid that kind of arrangement, because number one, you don't know who's going to manage the funds, and number two, you don't know if unless you want the 18-year-old to be receiving a lump sum of anything that's left over once they turn that age, it's probably not the best way to do it. A second way to do it is through a UTMA designation. A lot of banks can make this happen. It's UTMA is short for Uniform Transfers to Minors Act. It has two main components to that. The first being that it extends that age of majority to 21. So instead of getting a lump sum at age 18, it extends it to 21, which is a little better, still not ideal. But the second aspect of that is that you choose the custodian. So instead of it being whoever the conservator may be, you have a say in who's going to manage those funds for that child. Probably the best way, though, is to leave that bank account to them in trust. That trust is going to have the ability to manage it truly for their benefit. It's a little different than, say, some people will leave it to the parent of that child, or leave it to a grandparent or something like that, and say, well, that person can take care of those funds for that child. But then you're dealing with potential gift tax reporting, you're dealing with exposure to that other person's creditors, and in a trust you don't have any of that. You have a say as far as who's managing the money, how it's managed, how long it's going to be managed, and under what conditions it's going to be distributed to that child. So with a bank account, the best option is through a trust, or if there's no other reason to have a trust, then at least a UTMA designation instead of leaving it to that child directly. Thanks for watching. If you have any questions, you can always reach us at mellinglaw.com or at 435-572-0807.